had here. Everybody is welcome to the Judicial Service Conversations, and it's welcome because this is the Parliament of the Bar. It's a place where ideas are shaped, and so we want to welcome you to really to the Parliament of the Bar. And what we usually do is we ask a question. The very first question we ask all the people, and it's the first question we are going to ask you. And this question is simple, but it's about you. Many people who are listening know you. Many people saw you, I think, first saw you in the public arena in 2016. But many people also don't know you. But even those who know you don't know you. They know Jude, who is there, who is handling all these matters. So the first one we usually ask, tell us, Mr. Jude Biamukama, who are you and what makes you tick? Tell us the things about yourself that energize Mujenzi, who you know. We have Joy E. Mbabazi, and we have Alfred Muyakal, and they are all here, and each of them shall be sending some questions your way on this. So, guys, you're welcome. So the question, Jude, is who are you and what makes you tick?
Well, very interesting question, and one that I have not had to answer in a very long time. Well, when I talk about myself, I think there are so many things I can talk about. About my identity has so many things. I'm a father of 6 kids and one lawfully wedded wife. Yes, everyone is saying A in the room. Yeah. And I've been passionate about so many about governance since I was quite young. I think I wrote my first article about a constitutional issue when I was in my senior 6 vacation, and it was the letter of the day in the New Vision about the proposal to remove term limits. That was in my senior 6 vacation there, 2003. So I used to write quite a number of letters to the editor in those years, in my senior 6 vacation and my first years at campus. So I've always been interested about governance, but I also, of course, like a lot of other things. I like football very much. I played football since my childhood. I was on the school teams. I also played for Mitchell Hall in Makerere. I was captain of LDC as well, the back horse. I do many other things. I'm also a Catholic Christian by conviction, and that you also find a few writings here and there that I've made over the years online about that theme. I was about philosophy and things like that. I also used to actually host a program on a Catholic radio for over 7 years, once a week, some years back. So yeah, there are those parts about me, and what to do, practicing law, and the whole subject of law in my early years, I think around my senior 2. I fancied becoming a journalist. I used to like reading, especially. I used to love many newspaper columnists, Joachim Boembo, Lilian Balenzi. I used to like reading Robert Kabushenga in Kabale. Among my co-curricular responsibilities, I'm the president of St. Paul Seminary Old Boys Association. And some of my members lost their MP seats, like Honorable Wilfred Nwagawa. Dr. Nicholas Kamara, Kabale Municipality. Others retained their seats, like Henry Musasizi and Dr. Chris Wadiomunsi. So there's a lot I can talk about. I do not know what else you want me to talk about personal things, because there is a lot. I can talk about way outside this whole idea of a lawyer, because a lawyer is a job. It's not an identity. That's how I perceive it. A bit different from most of my friends in the profession. I look at it as a 9-to-5 thing, really, not an identity thing. So identity is when you say I'm a father, whether I'm at work or at home. It's something that's part of me. But a lawyer's job is something which you can even put aside and do other stuff once in a while. And that's me.
Thank Thank you very much, Jude. When you said that a lawyer is a job, not an identity, I have a friend whose wife is called Muchala Counsel. So I think for some people it's an identity, not a job. And when you talked of 6 children, I have another friend who I'm seeing online. I'm not going to mention his name, but every child he has been born after 9 months after one of his very big cases. So I don't know if your 6 children it shows the sort of high profile matters that you're handling, because in the midst of that stress. Anyway, let me not finish the sentence. This is the Judicial Service Conversations. If you're joining us, when you said you're on radio, one of our people here has also been on radio. So people may know the voice from radio, but I will not say who it is, except that it is not Alfred. But Alfred may have been in the seminary, but he may have left it for different reasons. Although I think he was not in the seminary as well. But thank you for that answer. If you're just joining us, welcome to the Judicial Service Conversations. We have none other than Mr. Jude Biamukama, and let me hand over straight to you, Joy.
Thank you very much. And thank you, Mr. Biamukama, for choosing to join us today. And for those of you that are joining us, we want to appreciate you. Thank you for choosing the Judicial Service Conversations with the lawyer's lawyer. And you know what they say, Olimujewa, when the time for election comes. Okay, so we have, I think that particular question that starts off our show is a very, very pertinent one, because sometimes we see people for what we see out there, but I think that addresses and makes them human and close to us, and it's good to know a little more about you as a person. Now, I just want to ask you something regarding Uganda Law Society, as someone who has been representing them and doing some good business with them, and I know people who are listening in right now also looking forward to this conversation. We know that you're counsel in the Uganda Law Society matters currently that are before court, and so if you could, in clear legal terms, say what would you say is the central issue that the court is being asked to determine? Thank you. Over to you.
Thank you. Obviously, I'm a bit constrained in what I can discuss regarding the court matters of Uganda Law Society. There's that whole issue of this sub judice rule, so we'll try to work within it. I don't think it's constitutional, but we shall respect it. I prefer to respect it until the day hopefully we can have an actual discussion and a resolution of how much we can discuss or not discuss about pending court matters. But that said, the crux of the disputes before the courts of law involving Uganda Law Society, it's governance, really. It's governance. And why they have become protracted and become difficult for the courts to resolve is precisely because I think the protagonists who took these matters to court may also not have had a very good appreciation of what their end game is supposed to be. Because you see, if my complaint before the court is that Uganda Law Society is doing something unlawful, fair enough. When I go before the courts of law and I take a professional association that has 5,000 members, either I want the court to quash what they have already decided, or I want the court to confirm whether a decision taken is lawful. But most of these cases have gotten lost in orders that simply prevent members of the association from meeting to weigh in and decide whether they are happy with the decisions taken by their leadership. And I don't think the people who, the lawyers who went to court, who took Uganda Law Society to court, I don't think their intention was that they didn't want Uganda Law Society members to be able to meet and take decisions. But that was the unintended effect of the path they chose. And maybe it shows why almost every professional body that has had a governance dispute go before the courts of law always fails to resolve it, and later on they go back to their meetings and agree. I know for a fact that the engineers have ever had this challenge. I think the most recent ones must be, is it surveyors? I think surveyors have also had exactly the same. You dispute who is the right leader, how did we elect. But at the end of the day, professional associations are about the consent of the members. And it's always going to be difficult for a court of law to dictate how members should think and run their affairs. What rather the courts should be doing, in my view, is to make sure that decision is taken by the leadership reflect the consent of the members. But to achieve your purpose of taking Uganda Law Society to court, all those have asked, they said, no, we have not. If I'm not happy with the leadership of Isaac Semakade, does that mean I should stop Uganda Law Society from having an AGM, for heaven's sake? I thought the AGM is where you make your case and say, you know what? I think the conduct of our president is unbecoming. Members, can we vote him out? You don't say, because I'm not happy, I'm scared that maybe the members, the leaders who are behaving in a wayward manner, have the mandate or have popular mandate, and therefore I'm trying to use the courts of law to frustrate popular mandate. You don't do that. And still it is, I think, an assumption. There should be. And so I find it very disheartening when a court of law makes it impossible for members to be able to meet and discuss how they want to be governed. And that is really one of the areas where I think our members who went to court may not have fully appreciated what they wanted to achieve. And at the end of the day, the leaders whom they are not happy with are the ones in office. Those leaders cannot even convene an election where they can be held accountable. Those leaders cannot convene a members' general meeting where members can ask them questions. So I do not know what ultimately has been achieved. The greatest harm that has resulted from the litigation instead is that it has created a very, very toxic engagement with the judiciary. And this engagement, again, was unnecessary, and the blame for it goes either way. I think on our end, there have been some mistakes that could have been avoided, but I also think the manner in which the litigation involving Uganda Law Society has been attended to from the side of the judiciary has not been proper, and there is room for both the bar and the bench to reconsider their approach over the existing litigation.
You can proceed.
Thank you very much. That was quite detailed, and like you said, protected from that view. But I think you also speak out exactly the mind of most of the listeners, are of course members of the Law Society and other members of the public who have been following this whole fracas, if I can call it that, for a moment. Because, like you say, when you ask the people who have been taking ULS to court, if they achieved the purpose for which they really started that, you say they were not satisfied. And then you've also mentioned the toxic engagement and what it has resulted into, especially with the judiciary, mostly the relationship with the. And then you also mentioned about something to do with going back to meetings to agree, because if this is where we are at, now the next question would be, would you say there's still room for alternative dispute resolution, that is ADR, within the Uganda Law Society? Or do you think that dispute has actually moved into territory that only judicial interpretation can resolve? What do you think?
I think the disputes before the courts will ultimately be resolved through alternative dispute resolution. That door cannot close. Why? Because the nature of the disputes before the courts are that even a judicial decision, whether from the High Court, whether from the Court of Appeal or the Supreme Court, may not be able to resolve some of the internal contradictions and debates that the members have and that people want to be resolved. At the end of the day, it's about governance is not something you can solve through the courts of law. Just like we have always known in the matrimonial law that there is that remedy, restitution of conjugal rights, which is provided for in the law. But which court of law is going to enforce it? And governance disputes also have that aspect, because you see they are about our will and mind. If members think this is the person we have chosen to lead us, there is a limit to how a court of law can block that. There is a limit. There can be questions about qualifications and all, but ultimately, leadership has also an aspect of legitimacy. Leadership is not just about legality. There is legality and there is legitimacy. What we should be focusing on is how to reconcile the two, legitimacy and legality. And therefore, I still think that ultimately, all the warring sides will get off their high horses and will sit down and we shall find a solution one way or the other. Because this impasse is not useful for anyone at the end of the day. I do not think the bulk of members are deriving any benefits from this impasse. Members may have the belief that, well, for us we chose our counsel and the others who are there, we extended their tenure. The others who are not happy with that may say, okay, we have also frustrated them and denied them legitimacy and made sure they are at loggerheads with the bench. See, there is a lot that goes on, but what exactly does Uganda Law Society exist to do? And it exists to obviously support the public in matters of rule of law. It exists to look at members' welfare, and it exists as a bar association. If it's unable to play its role, it's bad for both the bar and the bench. The quality of judges that we get on the bench is a reflection also of the quality of the bar. That's the reality. And that is why I'm amused when some people think members of the bench should be angels when they were devils at the bar. That's not how it works. If you get people who are indisciplined at the bar, it means tomorrow's judiciary will also be full of indisciplined judges. If the bar is dominated by people who want to go bare knuckles on every dispute, of course you are going to get judges who also go bare knuckles. It's simply because the bench comes from the bar, whether we like it or not. And it's always going to be very difficult for us to believe that you can have a disciplined bench that is impartial, that is fair, coming out of a bar that doesn't think those attributes are important. That's the bottom line. And that's why I think there has to be an engagement where both the bar and the bench recognize that they both need each other and they all feed into each other. More importantly, it's the bar feeds into the bench. Almost everyone who is at the bench, who is a judge, who is a magistrate, somehow they pass through the legal profession. A good number were members of Uganda Law Society. And therefore, they are still our people. And if we now criticize them and we don't like how they are approaching disputes and all, we need to ask ourselves, under which conditions did these judicial officers emerge? And what is if we are not happy with the quality of judicial officers we are getting, how are we as the bar reorienting ourselves to produce better quality judicial officers who are passionate about justice and who can uphold their judicial oath? Are we doing anything about it? Or we think by crying and kicking and shouting and abusing everyone, we shall end up having better judges in the future? It simply is not going to happen, in my view.
Thank you. Thank you very much. Thank you very much for that. And thank you once again to the people that are listening in to the Judicial Service Conversations as we discuss courts, counsel, and the future of practice. And we're having Mr. Jude Byamukama with us. And I think I want us to talk about the executive order. Is it wrong? This was talks about the expulsion.
This for him.
Or the expulsion of the AG. But then I think I want to pass it to you, Elison, to just take up with that. I am having issues with my sound. Thank you very much.
Okay, thank you for just joining us. We have Mr. Jude Byamukama, the lawyer's lawyer. Huh? If you're just joining us, we have Mr. Jude Byamukama, the lawyer's lawyer. I think we'll skip that question in the executive order because I think from the introduction that we had, I think that's part of the litigation, and maybe we shouldn't put counsel in a position where he has to mobilize public opinion for his case. But if you're just joining us, you said something about sometimes governance can't be resolved through court, and you gave the example of restitution of conjugal rights. And I think just for those members who are joining us and they do not know what restitution of conjugal rights is, it is something that you should Google, because all you have to know, it involves a matter of a situation where two people in a marriage are having a disagreement about about conjugal rights. So if you want to know how you can restore them through court, kindly Google. Now I'll hand over to Alfred.
Yeah, thank you, Elison. As you're Googling, just know conjugal rights. Some of you may have them during Valentine around there, which is coming. So that is also a hint. But if you're just joining the Parliament of the Bar, you're just on time. Today we are privileged to be having Counsel or Advocate Jude Byamukama. Is firing from all cylinders and is an all-round person. Just from the discussion we have had, you have already discovered he's a father, he's a footballer, he's a writer. He's an advocate who really, from this discussion, you know that dreams come true, because knowing that having watched the election petition in 2006, he discovered he wanted to be a lawyer, and then years later we see him. Personally, the first time I see him was during the presidential petition. So, and then he has already informed us that being a lawyer is just a job, it's not an identity. It's just 9 to 5. So we are privileged to have you after your 9 to 5 to have you into your time now. So we are discussing courtroom experience, clients, and courtroom experience, court and practice. We have already known that governance and because of the issues which we are having, the harm which has been caused by the litigation between ULS has caused the toxic relationship between the judicial and Uganda Law Society. And I think from my end, maybe this toxicity is also extending to the clients of the lawyers or the members of Uganda Law Society. And that will take me to my next question regarding practice of bail as current practice regarding bail, because before the current condition is young lawyers, even most lawyers would know, if I get a bail gig issued, I'm going to assure that bail application and I get some command. But now securing bail is a very, very big issue. Ordinarily, when you even go to court, before a lawyer could start trying to apply for bail, court would indicate the accused person of how he should proceed to apply for bail or what he wants from court. But now you see a scenario where you go to court and before you think of applying for bail, the matter is not on ECMIS, you cannot proceed. Before you know it, you have applied and they are adjourning the matter for ruling, and it's taking 1 or 2 months. So just looking at the current state of bail practice in Uganda, I just want you to see how do you describe it as a practitioner in that regard, and as a governance professional and a constitutional ethicist, because looking at the presumption of innocence, which is the really foundation of the right to apply for bail, is it really translating into a genuine presumption of liberty, or we are now using bail to constrain people's liberty? Thank you.
Thank you, Alfred. This subject of bail, I think, is it's one of those areas where we can say that the judiciary is letting down the citizens of this country, and we are entering a very dangerous times where the criminal justice system is getting weaponized through default remand without trial, without any judicial consideration. But maybe we need to first get to the basics, the first principles. What is bail about? You see, when I go to court and my client has been charged with a crime, when I apply for bail, I'm not saying my client is innocent. I'm just saying you have not convicted my client of any crime. There is no reason why he or she should be in prison. The only time my client who has not been convicted of an offense should be in prison is if the state is able to demonstrate that my client is going to dodge coming for trial. My client is going to run away. My client is a flight risk. My client is going to disappear. If you show that, then surely I may lose the ability to persuade the judge or magistrate why my client should go home while answering that criminal charge. That it's as basic as that. Now, we know, in fact, around 2005, 2006, we used to have judges such as retired Justice Edmond Semparugaizi, who had formed the view that for him bail was you ask and receive, because he had interpreted Article 23, Clause 6A of the Constitution about the right to apply for bail as creating an automatic right to bail. And so for him, his belief was he only has discretion to set the terms of the bail, but he can't reject a bail application. That was his approach. And there were others who didn't agree with that approach and took the view that they still have discretion to decide whether to give bail or not, following the law. The law in this case being, in the Magistrates Court, the Magistrates Courts Act, in the High Court, the Trial and Indictment Act. That question came to the fore in 2005 when Dr. Besigye was first charged with rape and then with treason. Justice Edmond Semparugaizi granted him and the co-accused bail. They were rearrested. Application went before now retired principal judge James Ogola. He again granted bail, but he framed the question for the Constitutional Court to determine if there was an automatic right to grant bail or there was discretion, and if so, what level of discretion. So the Constitutional Court answered that question and pointed out that there was no automatic right to bail, but there was an automatic right to apply. And because there is a right to apply, it means that discretion must be exercised in a manner that is fair. And the Constitutional Court emphasized what is critical is the accused person should be able to attend their trial. As long as they are able to demonstrate that, they should be released on bail. After that, some people thought other questions hadn't been answered, because the provisions on bail in the Magistrates Courts Act and the Trial and Indictment Act remained in place. In the High Court, we had that condition of bail can only be granted in exceptional cases, advanced age, no objection by the DPP. And ultimately, the Constitutional Court, in a separate petition, there was one called, I think, Foundation for Human Rights Initiative versus Attorney General. The Constitutional Court again emphasized that, yes, there is no right to apply for bail, but even those conditions are merely directory. In other words, persons applying for bail do not need to prove that they are of advanced age or they have medical illness. What was important is they need to prove they will come for trial, and the court needs to be satisfied. So for a while, I think after those decisions, it looked like bail had been settled. In fact, a few years later, in 2011, 2012, again another group, Honorable Sam Kutesa and others, went to the Constitutional Court to complain about automatic bail for accused persons who are committed for High Court. And again, the Constitutional Court said that was unconstitutional. If an accused person has been granted bail and has not defaulted on those terms, the mere fact that an accused person has been committed for trial to the High Court is not a bail. So the Constitutional Court, whose decisions were never challenged or appealed by to the Supreme Court, appeared to have settled the law. And then we enter now this very unbelievable territory where what we thought should be very obvious grants of bail began to be denied. I think the first most prominent one was the criminal charges involving the late Muhammad Sejirinya and Adan Sewanyana, whom a judge granted bail, claiming on a ruling that they would allegedly interfere with witnesses. And there was no such evidence brought before the court. The judge simply said, because they are members of parliament, has allegedly committed a very serious violent crime, they should be in detention while they are being tried. But you see, ordinary people never understood that there would be a day when the criminal justice system would more or less be weaponized. What do we mean when we say weaponized? A situation where people are not charged because they are going to be put on trial, but rather they are being charged as a form of punishment. In other words, the punishment is the process accused persons are being sentenced to. We charge you with an offense, and we know you are going to be remanded. Then eventually maybe you'll get bail, you'll be in prison, it will affect your health. When you come out, you've lost your liberty for some time, you have psychiatric effects, some even suffer serious bodily harm because of if someone had underlying conditions, they have not been able to get the best of medical care. So there is a lot. When someone is in jail, even if they are released after 1 week. In fact, one of my lawyer friends has been saying maybe it is time to change judicial training and require that every magistrate or judge should spend at least a month in prison, just so they can think about it when they are going to remand people mechanically. And I think that view needs to be thought about more carefully, because it's actually very because there is this idea that a magistrate thinks, well, anyone can go to jail even if for a week. I remember there was a case I think 2 years ago when a magistrate remanded an 85-year-old lady to prison, and when it made the news, even the director of public prosecutions then was alarmed and wondered, first of all, what's this case where an 85-year-old is charged? And it was a land dispute, coached as a criminal trespass case. And the DPP personally appears before the magistrate and says, but why wouldn't you give this lady bail at least on court's cognizance? And the magistrate says, I have discretion, and I exercised my discretion in that way. And that is one of the problems we have. Judicial officers apparently have formed the view that they have discretion to ignore the Constitution and decisions of the Constitutional Court. In other words, the custodians of the rule of law have also chosen the path of lawlessness. Because if the Constitutional Court has given guidance that, be liberal when it comes to bail. Be liberal. Yes, you can set terms, and if there is clear evidence that this accused might jump bail, and the evidence has been presented before you, in those cases you can deny bail. But you cannot deny bail that because you are feeling good that you have discretion. And so when that happens, that you have discretion to grant or not to grant, you get an environment in which the president's views begin to be reflected in practices of denying bail, even in the most obvious of cases. And this is not just about bail, it's about people's lives. We have people in Luzira prison on remand for the last 5 years who are not even appearing before any court. How can we still say those are accused persons? Those are not accused persons anymore. They have become they are prisoners, and they are neither convict. They are not on remand. They are not convicts. What causes that? Because someone decided that I don't have to grant bail. I can keep people in detention. Now the danger with using the criminal justice system for the purpose of simply detaining people, either because you are trying to because I've listened to the arguments back and forth that maybe people are likely to protest. You keep them on remand for some weeks, then or months, then give them bail later. But that's not the purpose of the criminal justice system. The criminal justice system does not exist for purposes of creating public order through keeping people away when they are not convicts. Someone is either a criminal or they are not. If you don't like my behavior but I haven't committed a crime, you cannot take me to prison because you don't like how I talk, or you are worried that I might commit a crime. You cannot therefore create for me a crime and then take me to prison for on remand for some days or some months. The danger is sometimes there are people who are remanded on charges, and the people who were officially the complainants even forget that there are people who are in prison on their behalf. And then you find someone has spent 2 years, 3 years on remand. Not everyone has the capacity to apply for bail, by the way. There are people who are on remand and they can't even get sureties, people to stand guarantee for them that they will come for trial. Why? Because probably people get caught up. There is a protest. The law enforcement is rounding up everyone within the scene. A fellow has come from up country, does not even have relatives in Kampala, and is taken to Buganda Road, is charged in a group, and is remanded to Luzira prison. And then it takes even the relatives to hear that this man is actually in Luzira prison 2 years later. So there is a lot that happens when a criminal justice system is used for the ends to which it was not intended. The criminal justice system is not intended to police people in the manner in which it's being done. And that is why this idea that bail can be mechanically granted or denied is very dangerous. The guidelines which we had from the Constitutional Court were sufficient. The bail guidelines which Chief Justice Emeritus gave the courts obviously created a bit of a problem, but even then, I am not a very strong critic of those bail guidelines. In my view, they didn't create a situation where judges or magistrates were stopped from granting bail on the usual terms. They were given guidelines. We can always debate some of the guidelines. For example, the bail guidelines for the Anti-Corruption Division, which require, if you are charged with an offense causing financial loss of 1 billion, they want you to bring a guarantee or a surety who has a bank statement that shows that their net worth is probably around 400, 500 million. Now, what if I'm charged with causing a financial loss of 1 billion and I've never even touched 5 million in my life? I've had all those scenarios where a person is charged with an offense involving large sums of money which are simply outrageous and have no basis in the actual accounting terms. But the person is being told, you are going to deposit 50 million Uganda shillings. Your sureties must have bank statements showing that they can at least afford some 600, 800 million. Those are real problems, and those are intrusions on the right to apply for bail, because the concept of a right to apply for bail means that right should not be fettered. It should not be controlled by some stringent conditions. A magistrate or judge should still be able to make the call that these accused persons might jump bail. You can make that call if there is evidence. You can't assume that I will jump bail because I own a passport. No. Or because I've been out of the country before. No. You can simply say I will jump bail if I've either I have jumped bail before and you know it, or the prosecution has brought evidence showing that I have planned it to. There should be evidence. You cannot simply deny me bail over 4 years or months. People don't need criminal trials anymore. Even the government does not need criminal trials anymore. 4 years or months. People don't need criminal trials anymore. Even the government does not need criminal trials anymore. If they know a person who is suspected of having committed an offense can be charged and remanded for 5 years, why should they invest resources in the trials? There's no point. And no wonder we have a backlog of criminal cases that can't go to trial. If you were to do a census today of people who are on remand waiting for trial, they are in their thousands. But there's no interest in trying them. That's the whole point. And some of them might be guilty if they are tried. Some might be innocent. But the whole point is the system was designed to separate the guilty from the innocent. The system wasn't designed to allow the police, to allow security agencies to lump up everyone they come across and dump them in prison and forget about them. You'll find investigating officers who have since forgotten that they prepared the file, then a charge sheet, then someone was remanded, and it's been 5 years. They don't even remember. So we are corrupting the criminal justice system, and I think it's high time for the judiciary to recognize that they are doing lasting harm to the criminal justice system if they do not reconsider their approach on this question of bail. It's okay for President Museveni to have his views about bail, but those views have not made it into the law. If they make it into the law, well, then you follow them, but they are not the law. And there is no reason why he shouldn't have his views. I also have my views. I think the 48 hours probably were not a very good idea. I think we should be having the Kenyan way of where if you arrest a person within 24 hours, 48 hours, take them before a magistrate, then justify why you need to continue detaining them as you investigate. I think that would be a better system. Personally, that's what I think. Because now the 48-hour rule creates a situation where the police rush to create criminal offenses because they are worried that, this person is now under illegal detention. Let's just charge them. That whole notion of a so-called holding charge, it arises because of the 48-hour rule. Realistically, how can you investigate a complicated crime in 48 hours? It's not possible. So either you will say, first do your investigation is thoroughly. When you are sure is when you should charge someone. But people who have committed a crime are going to run away if you do that. So there has to be a balance. A balance between if a person has been charged with a crime or is a suspect, maybe go present that evidence before a magistrate and then justify why you should detain them for another, whether 1 week, 2 weeks, before you can charge them, so that one, you don't bring a charge for the sake of it because you want to hold someone who is innocent. I have represented people charged with murder, and 2 years after investigations they are released. But you have killed someone 2 years that you can never give them back. So it's probably the approach under the new Kenyan Constitution, the Kenyan Constitution of 2010, maybe something to look at. But we cannot sit and have that conversation when we are having a situation where the criminal justice system is being weaponized to go against political opponents. You have all those youths of National Unity Platform. I know around 9 who have been on remand, I think, since 2021. Honestly, how can we still say they are even on remand? For 4 years, 5 years, is someone on remand? You have individuals charged with common nuisance, an offense which is a misdemeanor, which probably attracts even a fine on conviction. and you have people on remand for 5 months on a charge of common nuisance, on a charge of illegal drilling that they could find, which many of us can agree with. But you can't promise us that you want violent criminals kept off the streets. Then tomorrow we are seeing people who happen to be contesting for political office and they are charged with common nuisance, they are charged with illegal drilling, and they are also on remand for 7 months. We of course will know that what you are saying, you are simply gaslighting us. You were telling us you don't want bail to be lenient for actual criminals, but ultimately what we are seeing are political opponents that are on the receiving end of denial of bail. And that is why it becomes difficult for people to recognize that there could be cases where people can be fairly denied bail. But whether those cases exist is difficult to say. When we see somebody is an elected member of parliament or is contesting for parliament, is a leader in a political party, and they are denied bail for 9 months, 1 year, 2 years, and they are not going on trial, of course, we are never going to believe you when you tell us that you genuinely mean that bail should only be difficult for criminals and not minor offenders. So it's an issue that we need to think about more carefully, and bail is soiling the image of the judiciary. The manner in which they are handling bail is soiling the image of the judiciary. I would wish them to recognize, judicial officers to recognize that they don't need this. We don't need to record 20 years from now that there was a time we had a judiciary which used to remand people for 5 years for non-offenses.
Bail. I think from your submissions, a person on call can deduce that bail ought to be something which you ask and receive, and the also is to grant you bail on the terms it deems fit. But as you noted, judiciary is letting down the sense of this country as regards bail. So a person on call, or anyone on call who's a lawyer, is wondering or would want to be reminded on what are those basic legal factors courts must consider when determining bail, and whether those factors are being applied consistently. Because once you know this, even when you're going to court and you don't have a lawyer, you can easily apply. And even when you're a lawyer, you can always consider those factors that they are met before you start applying for bail. Thank you.
Like I indicated, you see, bail is about it's an agreement between the accused and the court that I should not be detained. I know I have this charge that has been brought against me. I'm looking forward to my day in court. I will come to answer this charge. I'm committing, I will come to answer this charge. And since I'm the accused person, you may not trust my word because I could turn out to be a liar. Therefore, I have brought 2 people who can confirm that and who are willing to put their arms on the line for me. In other words, the sureties, who are willing to say, I will come to attend to this trial. What does the court require? Generally, so you'll find, one, if you are an accused person, the court needs to know where you stay so that should you jump bail, they know where to find you. That's why you'll find the accused person's letter of introduction for their LC1 to know where their LC1 residence is. That's the smallest unit, where they stay. I remember as many years ago when I handled my very first bail application, must have been around 2011, before now retired Justice Paul Mugamba. He was then in the anti-corruption court. I applied for bail for a young man, and in my application I put that he has a fixed place of board in Kampala. And the judge asked me, what do you mean by Kampala? And I told him, no, he stays here in Kampala. He said, no, Kampala is very big. Then I said, no, he lives in Makerere University. I said, okay. So now you need an affidavit and an LC1 letter to confirm he lives in Makerere University. So that's the purpose of an LC1 letter. For the court to be satisfied, and the prosecution which has brought the charge that you live in a particular place. If you disappear, they know where to begin from. Similarly, the people who guarantee to the court that you are going to come and stand trial must make the same commitment. So where they live is important. That's why they need letters of introduction from their LC1s. And then, of course, copies of their national IDs. So ideally, obviously, there should be people who have some level of responsibility and control over you. You are not going to bring your subordinate to stand surety for you. And a father is not going to bring a son to stand surety for them. There are those dynamics, but they are really simple common sense rules. Because what is the overall goal for bail? A commitment to come and attend trial. That's one. And a commitment, if the court decides to forfeit a certain sum of money, should you jump bail. So those safeguards, for me, are quite are strong enough. It's true we have had very few cases of individuals jumping bail. That at a wild guess, I don't think 5% of accused person is jump bail. Even 5% is probably too high. Maybe 1%. People will attend trial, but also jumping bail happens from the few cases I've come across when a criminal trial takes forever to happen. I once represented a gentleman who jumped bail. And what caused it? For 5 years, he was not being tried for 5 years. How can I be a suspect on trial for 5 years? I need to move on with my life. So he stopped reporting to court and moved on. He didn't leave the country. He stayed in Kampala. He even forgot he was an accused person and was rearrested when he had gone to get police bond for another suspect. So even people jumping bond at times is something that can happen because of that attitude towards the criminal justice system. And therefore, an accused person shouldn't actually need a lawyer to get bail. And that's how the system has been in the magistrates' courts, really. They shouldn't need. What's important, what is really a deal breaker is, do you have people to stand surety for you? But also, if you are a very prominent person who obviously can't jump bail, you are a member of parliament. It is your first 7 months in your term of office. Why would you jump bail and abandon what on the face of it is a lucrative political position? Hardly anyone is going to do that. Members of parliament used to be granted bail. I remember Akbar Hussein Godi was granted bail for a murder trial when he was a member of parliament. He still attended his trial. He was convicted by the High Court, by the Court of Appeal, by the Supreme Court. But he had been granted bail and he was around. So I wouldn't understand when a person of that magnitude is denied bail without really mechanically. But those are the prominent ones. The other lesser individuals, people don't just jump bail. And law enforcement, the people in security, whether Uganda police and all the others, have a job to do. That is why an accused person is supposed to provide a clear address. But also, typically, by the time the police is arresting an accused person and bringing him to court, in many cases, they even know where the accused person lives. So it is even funny that an accused should prove where they live. And yet the same information in some cases is even on the charge sheet that Amero Adarit so and so by the ethnicity resident of this profession is charged with the following offense. And then the magistrate is saying, but where do you live? Counsel, where is that information? The accused person is placed overboard. Yet the information is on the charge sheet. So it's I think it's an attitude problem that needs to be broken down through conscientizing judicial officers that we all want a criminal justice system that works, where the actual criminals are charged, prosecuted, and convicted, and the innocent do not get victimized by the criminal justice system. A person charged with an offense and acquitted should be able to move on with their lives without the trauma of having been on trial and on remand for years. It's a situation that people should know, and accused persons should continue to apply for bail, even if they think the bail is not going to be granted. even if the magistrate has told you, I won't give you bail, apply and let it be on record that you were denied bail. Maybe one day we shall have reparations and the day of accountability for judicial officers who are mechanically remanding innocent people. So make the application. Don't fear to apply for bail. Apply and let put the judicial officer on record that you have applied for bail and they have chosen wantonly to deny it. Let it be on record, because that record will one day be useful.
Thank you very much. You raise some very good issues, pertinent, and I think that is complaints in the public square, if I might say. That is the conversation that is going on, especially I think this whole month of January. It's been quite chaotic, and I must say the public is losing interest and trust in the judiciary every passing day. And you make, I think in your conversation, you have indicated or alluded to certain things or ideas or resolutions that could actually come in as solutions. So I want to push it back to you and say, I think you make good recommendations, but what would you say? Because it's been, this particular space has been called the parliament, the bar. And I want to believe that the conversations we have here are conversations that affect not just the lawyers, but also the public. And we also have people, the players, everybody, somehow the information gets there. So what you say is the right way, the path forward? Because we can talk about it, but how do we put it into practice? What would be the next steps to actualize the ideas, the recommendations, so that at least we have some progress? Over to you. Thank you.
Of law. The problem is not the law. The problem is not the constitution. We don't need any constitutional amendment. We don't need any amendment in any law. We don't need any pronouncement of the constitutional court. Everything is settled. What we need are judicial officers who can follow the existing law. Yes, we may have a few problems that some judicial officers now probably have even forgotten the law. Maybe Judicial Training Institute, for which I have occasionally facilitated a training, should think about this area. There is no reason, there is nothing in the law that needs to change. What needs to change is the attitude of judicial officers towards bail, the attitude of the prosecution, the Directorate of Public Prosecution, the Inspectorate of Government towards bail. To be fair, the Inspectorate of Government, I think the people they charge are don't complain that much about bail, because the practice in the anti-corruption division doesn't seem as stringent from what I've observed over the years practicing there. The problems we are getting about bail, if I can speak very candidly, are about people charged with offenses arising out of politics. They are not routine matters. And you see, this is now it is intruding onto other matters. Because if you charge people with an offense of common nuisance, an offense which attracts even a fine on conviction, already the way the law was written in the almost 100 years ago, that penal code, the assumption was, yes, it's an offense, but it's not an offense that requires you to go and be in prison, in custody. That's the assumption of some of those offenses. So we have offenses for which bail should almost be a given. Common nuisance. That offense, illegal drilling, which a number of National Unity platform supporters were charged with over the parades they were conducting. And you remind someone like that it's a scandal even to remind them for a week. But now people are reminded for 6 months. It's simply ridiculous. So what we need to understand is, let's keep politics out of bail decisions. Whether someone is a politician, whether someone commits a nuisance today, allegedly, then comes back another day and another day and another day, they have not been convicted. It doesn't matter that I'm charged 4 times before 4 different courts. It doesn't mean anything until I'm convicted. Then you can say, oh, but you are a convict. Now we are going to deny you bail here because you are a convict on this offense. And this is similar to what you have done. Though again, in terms of the law, Article 28, Clause 3 of our Constitution, see, the presumption of innocence is self-contained to every criminal trial. So even the fact that I've been a convict in another matter may be irrelevant. So for me, judicial officers need to get this message rammed into them. Of course, the leadership of the judiciary would have to play a role in this, from the Honorable Chief Justice, the Deputy Chief, and then the Principal Judge, and then the Chief Registrar, and the magistrates. They simply need to understand that there's no reason why we should be crowding prisons with people charged with very petty offenses, and many of whom never go on trial anyway. Criminal trespass. You have someone charged with criminal trespass and is on remand. So it's I think it's an area that requires a more proactive engagement with a bench, and but of course the bench must be willing to listen and to this. And maybe it would also be good to have a conversation with the President Museveni to understand that his utterances about bail appear to be intimidating judicial officers not to grant bail even in obvious cases. Because the times I've listened to him, I've watched a video of President Museveni from 1988 when he was talking about this bail issue. And his argument was always about murderers, violent crime. But even then, the assumption always was, you see, someone commits an offense and is going for trial. But now the prosecution is not ready for trial, but wants people to be locked up. It can't work that way. If you are going to put people on remand, try them immediately. That's for violent crime. But you see, the nature of the offense also dictates how you approach bail. But like I've said, for me, this conversation about bail, we are in an environment where it is impossible to have a good conversation. It has been crowded by politics. We have so many cases that smell of political persecution. The moment you charge a person who is involved in politics with an offense, and then the judge or magistrate ignores all the rules that exist, we call that political persecution. It ceases being a criminal a suspect on remand. The law says a misdemeanor, give the person bail. You are denying someone bail on the smallest, the pettiest of offenses. How are we supposed to assume that you are following the law when clearly you are ignoring the law? That's the meaning of political persecution. When we talk about weaponizing the criminal justice system, you are putting someone into the criminal justice system to punish them. You are sure they are not guilty of an offense, but you are sure that the inconvenience they are going to go through in getting bail will make them abandon whatever activism they were engaged in. You have not said the activism is not illegal. You don't like it, you simply don't like it. But you say, okay, we are going to charge you with an offense. By the time you get bail, you have been on remand for even if 1 month, 2 months. I know people who have been granted bail and have developed medical complications for the rest of their lives after just a couple of months. And therefore, this area needs to be, it requires judicial officers to be considerate. And that's why I said earlier that I have sympathy for that view, that maybe judicial officers should once in a while spend some time on remand just to see whether it's something they would want for an innocent person.
Discussion on bail, and we're also glad we have our radical new vice president, Mr. Elison, who has also been so much in the bail applications. But before you leave this conversation, you have been hinting on political related cases and regarding bail. So when in regard to politically sensitive cases, how can courts, or how should they balance individual liberty, public order, and confidence in the justice system when it comes to political cases and bail? Thank you.
When it comes to, first of all, of course, in law we have no such thing like political cases. So that itself is a political term.
Yes.
Because when we talk in very pure terms, like you see our constitution, article is it 21, talks about equality before the law. The concept of equality before the law means whether I'm a politician or a mere citizen, a muntu wa bulijjo, as it were, just an ordinary person, we should all have the same rights. If the ordinary person has the right to apply for bail, even the most powerful of politicians should have the same right to apply for bail. And that's the only way. The judiciary is supposed to be an arbiter between the powerful and the weak. Both should have the same rights. I remember Chief Justice Emeritus Bat Katurebe used to say that, for him in his chambers, he had the images of Saddam Hussein, Pope John Paul II, to remind himself that if they all to appear before him, they deserved the same measure of justice. That's how it should be. The most unpopular person in the country, or in the eyes of the Uganda police, or in the eyes of the army, should have the same measure of justice as the most popular person. And I have made this argument. I have represented individuals charged with offenses in the anti-corruption court. Then some friends were saying, those ones, how come for them they go to bail immediately? And I told them to look, but that's how it's supposed to be. That's the whole point. If I'm a cabinet minister and I apply for bail, I should get it on the same terms. But you are saying because X, Y, and Z, because the late Sejirinya was denied bail, because the former MP Alan Swanyana was denied bail, I should not get, other people should also be denied bail. No, that's not equality before the law. When there are mistakes, when there are aberrations, when there are errors, we should not choose the others who are not victims of those errors. We shouldn't say, because some powerful people are given bail, therefore it means the judiciary is not working well. We should be saying equality before the law should mean the same thing for everyone. The powerful, the wealthy, the poor, the weak. And the judiciary needs to understand that for us, for citizens, what they look at is how you handle the cases involving the powerful and the mighty influences how they perceive justice. If they think the powerful have their way before the courts of law, that's the beginning of ordinary people losing faith in the judiciary. And it's very tempting for judicial officers to think that it is meaningless and irrelevant for ordinary people to lose trust in the judiciary. But they should remember that the legitimacy that the judiciary has, the moral force that any judiciary has anywhere in the world, is derived from that public acknowledgement that citizens recognize that you are our arbiter. Because the moment we lose faith in the judiciary as an arbiter, then we shall resolve, conflicts will be resolved in other ways. Maybe we can put in a small football analogy to remind everyone. When you see that African Cup of Nations final that was getting chaotic between Senegal and Morocco, because the Senegalese had lost faith in the referee, that's what you get. And that's what I think we are going to get in the future. Because if ordinary people lose faith in the judiciary, fine, the judges can continue getting their salaries, they can continue having their privileged terms, they can continue remanding people, they can continue helping the system to remand people, they can dismiss election petitions of people who are not popular and who are not influential. They can do everything they want. But the bottom line is, if the ordinary people lose faith in the judiciary, these powerful people who give privileges to the judiciary, the executive, will also see no need for the judiciary. Because if I'm charged with an offense and I know that I can't get bail because the judge is worried, President Museveni has said no bail for people charged with murder, So why should I apply for bail from the courts of law when I can write to State House? Then I'll go and ask the president, Your Excellency, my person was unfairly charged. Actually, there is no case. Please talk to DPP to drop the charge. Or please call the call the judge. That's what the judiciary. That's the message the judiciary is sending. Because the whole point of the judiciary is that there is one of its roles is to be an arbiter between the ordinary people and the institutions of the state. But if the judiciary has taken the view that it is always going to rule in favor of institutions of the state, then what's the point of ordinary citizens turning to the judiciary when they have their own problems? They're also turning to those other institutions apart from the judiciary. And so a point can reach where citizens see no need for the judiciary. I remember a grade 1 magistrate friend of mine in one of the upcountry locations I wouldn't mention was upset that people don't actually file civil cases. He says his court has civil cases and criminal cases, but in a year he can barely register 20 civil cases because the people hardly take civil disputes to court. They prefer to resolve them customarily with the Kirani elders, and criminal matters come because the Uganda police force is forcing people to come. And still, those are a few offenses. In other words, a judiciary can actually become irrelevant to the ordinary lives of the people. I agree, it can take time. And that's why people in the judiciary today may not realize it. But it can 10, 20 years. If today we are filing election petitions and we are told that, what is the political affiliation? That one, of course, will be dismissed. Later, people will say, but okay, so when I'm cheated, there is no point in filing an election petition. They will not file them anymore. But it doesn't mean they won't find another avenue for expressing their discontent. And that's why I remember Justice Sekoko in his dissenting judgment, must be from 2006, 2001 or 2006, I don't recall which petition one. He warned that if the courts make it impossible to annul the result of a presidential election, for instance, it means they create an avenue where people who are dissatisfied can become a risk to stability in a society. The judiciary plays a role of creating a stable society. You cannot create a stable society where you have people who are aggrieved and have nowhere where they can confidently feel their grievances can be examined and addressed fairly. If I think that if I'm standing for MP and if I lose, there's no point in me filing an election petition. I'm going to start looking for other avenues of expressing discontent, which probably may create instability in my constituency. You'll hear cases. So and so's home was burnt. Supporters are killing each other over an MP seat. We have been seeing this anyway already in some places. Why should ordinary citizens kill each other over an MP election? But it's because they have been told it is a winner takes it all. Forget about the judiciary. If your political affiliation does not seem to be right, forget about your petition being heard on the merits. So people are going to be fighting. People are going to be fighting because they know the winner takes it all. Forget about the judiciary. This idea that the judiciary will, in some cases, rule in favor of the weak against the mighty. Once that idea is eroded, you don't have a judiciary.
Thank you for just joining us. Welcome to the Judicial Service Conversations. We're having frank and fantastic conversation with Jude. Jude, I'm getting a lot of messages. We're going to go to Mercy next, and we're going to go to that point which was touched on, electoral justice, I think. But Mercy, before we get to you, maybe Jude, just in a few minutes, I'm getting a lot of pushback from very many places. I'm going to read for you some of the pushback I'm getting. I'm also hearing support. So I'm hearing support, for example, the Vice President of the Law Society suggested it's not just state attorneys, it's not just magistrates who should be sent to Ruzira to learn. He thinks state attorneys should be sent there as well. I know a certain colleague of mine who thinks all lawyers should actually be taken to jail. I told him to just speak for himself. And just to make it clear, we are not in favor here in the Judicial Service Conversations of incarcerating the judiciary. But I'm seeing a lot of support. Some people are talking about reduced productivity and all that. But I'm seeing two particular people who are, I'll not mention their names, they're pushing back. Someone is saying thousands of cases are heard throughout Uganda. These cases include bail hearings. Bail is being granted throughout the country without noise. And that the uproar about bail is just loud noise about a few cases. And it is being unfair to the hundreds of judicial officers who are granting bail across the country. Another person has sent me a message pushing back and saying we are looking at bail outside of the public order context. I think they're pushing back at your comments on the criminal justice system was not intended or for public order. And I have a message from somebody who works in the public order space who is saying that in fact their work is to keep law and order. And the only place they can take you to is to the courts, and that the courts must therefore strike a balance. The third pushback I'm seeing from someone is they're saying what you're suggesting is about rich people's bail. That all this whole surety money business is that sometimes that the rich also cry. If that's the word they are using. Someone is saying the rich also cry. Yes. For ordinary people, that's what I'm seeing, who go to court and they are told to squat as they are waiting to be read their charges. That for them bail has never been an option. And that the only difference right now is the rich are also crying. This is now a person who has a problem with rich people. And so, if you could just give us in just 2 minutes so that we can move to that the issue, because you're touching issue of electoral justice, that pushback. But the whole idea is that, I think the whole idea is well expressed in those questions. I think that I'm seeing also a comment about studies on the cost of bail, saying holding nearly 50% of prisoners on bail, lost productivity, need for extra guards, expert spend on food. But we're also going to talk about, and maybe you can hold those answers back, this business of 5 years on remand. Actually, we have people on 10 years, we have people on 7 years, where pretrial remand has become a punishment. And we're also going to come to that. So maybe if you could handle some of those questions, and then very briefly, and then we'll go to Mercy Makabai Chemotai, who will be asking you other questions as well.
Okay, just a quick response. Yes, it's true that generally bail had ceased being controversial. If the listener who posed that question, that bail is granted almost all over the country, that's what we have always known. I gave the background to the genesis of bail and where we are now. And I also put a caveat that increasingly we are seeing that in the cases smearing of politics, there seems to be a reluctance to grant bail. But those cases are gradually intruding onto even ordinary cases where bail never used to be controversial. And therefore, we need to sound the alarm. We need to sound the alarm already. Thousands of cases, in thousands of cases, it is true people are granted bail. But increasingly, what started with isolated cases dealing with the politicians will soon spread to everyone else. Just to remind the author of this comment that the cases which went to the Constitutional Court about bail were by politicians. The starting point was the constitutional reference of Dr. Besigye, which was framed by Justice Ogo
and Anba Hitman. Well,
obviously, there is case, there is a value judgment that the judges made in this particular case. There is a value judgment which judges made even in Dr. Besige's case, because when a judge, like any other lawyer, is faced with a case, the way you apply your legal principles, sometimes there's that value judgment of, this is likely to be an innocent person, this is likely to be a guilty person. And I remember even the Constitutional Court made another judgment a few years ago involving the question of the suspects of the Chadondo bombings who were complaining about violation of their rights. And the Constitutional Court seemed to be walking back its own decisions, saying these ones where an offense is very grave, the court should be mindful of how it approaches the question of even violation of rights. But I think what's important for us to recognize is the legal system by its very nature almost world over. People with resources are able to push the legal system to its limits. And people without resources, sometimes the legal will simply be processed through the system.
They're pushed to their limits.
That is the reality of the situation. That is why legal aid ought to be mandatory. And instead what we have are state briefs, which are, with due respect, tend to be
too modest.
You are not going to get lawyers to commit time if you are going to pay them whether 1 million Uganda shillings to a criminal trial for a capital offense. And therefore, the nature of our society, if you are getting into the political economy of bail, is that going to the Constitutional Court, again, is going to require people who are able to move their case. But again, this shouldn't be happening if the judiciary created a system where anyone is able to have their day in court. I have seen judgments in criminal cases where some accused persons have been acquitted, especially by the Court of Appeal and the Supreme Court, based on principles that don't have to do with the lawyers who have argued the case per se. In other words, the judges go out of their way. And I did raise a complaint one time in a more administrative meeting with the justices. And the one judge pointed out that, you see, the way we approach criminal cases is not the same way we approach civil matters. Criminal cases, the reality is most of the accused persons, either who have been convicted and are now appealing, most of them don't even have resources. They tend to be, those they're calling the poor. And so the judges appear to go out of their way to be sure these people have gotten fair justice. So you'll find the Court of Appeal ordering retrials, reducing sentences. But when you look at the way they approach civil matters, where they think parties are all balanced in terms of resources, the approach is a bit different. And this need not be the case. Even in civil matters, it should be the same approach. A litigant may come and doesn't have the resources, but has a fair cause before the court. It doesn't matter that this litigant is suing whether one of the wealthiest blue chip companies in the country. They should get fair justice. That is the concept. But I think this concept tends to get lost in civil matters, and then some justices remember it in criminal matters. I see especially the Court of Appeal and the Supreme Court. I've seen people, I think I've even seen people being acquitted when they are self-represented. I've seen a couple of matters, in criminal matters, where self-represented people have been acquitted at the Court of Appeal. But to turn to this question of public order, public order cannot be managed using the criminal justice system to remand people. That's not how you achieve public order. We all want public order. That's for sure. Public order is achieved in various ways. And the most obvious is, of course, preventive action. But you see, preventive action, if you think people are going to stage a violent protest and you deploy adequately, you likely will not have that protest. But if you say, you suspect me, I'm going to lead a violent protest, then you arrest me and charge me and remand me for 6 months. You see, you might have had an end goal. It may be possible that maybe I was planning a violent protest. But in trying to contain me, you are doing harm to the criminal justice system without recognizing the consequences of your action. Because when you start to get people whom you are not planning to try, and I know for sure this is what is happening. You create a charge sheet, you charge me with incitement, and then you remand me, but deep down the investigating officer knows, this man, there is no criminal offense here. We simply want him to cool down. There is a lot of tension. People might protest. We are trying to nip in the bud any attempt at protest. You are using the criminal justice system for ends for which it was never intended. The criminal justice system is not intended as a buffer for law enforcement to avoid dealing with the protesters. Law enforcement, if it needs more resources, and that's why they are trying to use the courts of law, should instead ask for more resources to have better ways of containing whether violent protests or people who are committing crime. But the moment you have decided that I have committed an offense, for heaven's sake, take me on trial. If you don't intend to put me on trial, you have no business taking me to a court of law. And that distinction, I think, gets lost every time I discuss this area with people in law enforcement. But like I said, for me, I'm always open to a good discussion about bail. But the current environment has been clouded by the abuse of the criminal justice system, that it's difficult to persuade any fair-minded person. For example, that, these people want to remand for these offenses, common nuisance, illegal drilling, that they are on remand genuinely for 6 months. You see that the criminal justice system is being used for different ends. And even people in law enforcement should not be happy about this. Because when you start putting innocent people in jail, tomorrow when you put real criminals in jail, we shall not tell the difference. We cannot tell whether this person on remand is a criminal or is another innocent person who is just caught up in the system. But ordinary citizens should be able to tell the difference. For me to know that if I commit a crime, I could go to jail. But if I see people who haven't committed crimes and they are in jail, then I'm going to know that, well, anytime I can go to jail, whether I'm a criminal or not. And if that's the attitude I have towards law enforcement, towards the criminal justice system, then I will not trust it. I believe that even people who are criminals would be able to thrive in that environment, because real criminals know and real criminals thrive in a society where we can't tell the difference between criminals and innocent people. And that is exactly the harm that is happening to our criminal justice system.
Okay.
Perhaps maybe the question about rich people's bail. Yes, ordinary people will continue to suffer more than the rich. That's for sure. We can't deny it. And like I said, the whole reason why governments exist, a government is supposed to cater for the common good. In other words, to bridge that gap between the wealthy and the not so wealthy. How is that gap bridged? The wealthy pay taxes. Those taxes should provide services that everyone can benefit from. When roads are constructed, even the poor can walk on them. So, legal aid. Taxes can support legal aid so that even the poor man can afford a lawyer who can represent him. That's how you'll find societies having well-funded legal aid, having well-funded public defenders to bridge that gap between the poor and the rich within the criminal justice system. But it's a weakness. I know we have had a bill before Parliament for many years, which government is not happy about, trying to compel government to provide legal aid. Maybe those are some of the conversations that some of the players should be thinking about, because that's what will genuinely bridge the gap. But as it stands, if everybody has to pick their legal bill, of course, there will always be that disconnect between the wealthy, the haves and the have-nots, as people would want to frame it.
Okay. Thank you. Thank you, Jude. If you're just joining us, welcome to the Judicial Service Conversations. We're having a fantastic conversation with Jude, firing on all cylinders. We've got a few comments, and I move to Mercy. Just hold on, Mercy, for a minute. I think we've just got a few comments, which I'll just read out. First, a criticism of us from my learned friend Anthony Odur, who says that anonymizing persons voicing these concerns about bail is unfair. For transparency purposes, it would be great to mention their names. I think let's give them intellectual and ideological bail. If they don't want their names mentioned, we shall respect their rights, especially the guy who is complaining about rich people. Then Anisha Sumaya says that Counsel Jude is a prophet of doom. I think she says this nicely. I've never seen this phrase used with such admiration. He's speaking real-time truth without fear or favor or ill will. I think we had read Natif's comment about studies on the cost of holding nearly 50% prisoners on bail. The vice president says that, he suggests that state attorneys should be remanded. I'm sure that those members of the Law Society, if remanded, the vice president would run very fast to their defense. We have Enoch Seguya, who says that in the context of Uganda's judiciary, there are systemic delays and corruption allegations that often undermine public trust. How can lawyers ethically transition into roles as mission-based judges? And we'll come to mission-based judges later. Now, if you're just joining us, we are having a fantastic conversation with Jude Biamukama, who is a lawyer of vast depth, absolute breadth, complete clarity, absolute eloquence, as you can hear and confirm for yourselves. And Jude, I want to hand over now to another lawyer called Mercy Chemutai Makabai, who is also a lawyer of such depth, clarity of mind, and eloquence, who wants to ask you questions totally unrelated to bail. Over to you, Mercy.
Thank you very much, Elison. I think being away allows me to get such a great introduction from you. Thank you very much. Jude, it's indeed an honor to host you today. Unfortunately, I couldn't meet you because I was coming from Masaka, but I do have an opportunity to ask you a couple of questions on electoral justice. But I do agree with Madam, I think, Anisha Sumaya's comment. The quality of the information you're sharing with us today makes me excited to look at your side hustle doctoral work that you've talked about, because there's depth and there's quality, and also the information is very timely, both for the law community, but I think just for the public, the general public, to understand the environment we're working with legally and in terms of the political space and the judiciary, and to know that you could sit back, but a day will come when you need to fight for yourself, and you need to be aware of your rights, and you need to be aware of the options available to you in order for you to get some form of equality in the way the systems work. Just moving into this issue of electoral justice, we know that there are a number of decisions being made right now following the recently concluded elections. There have been recounts, and I think a number of people who are in the general public would ask themselves, what must someone who is going to make a petition in court about parliamentary election, what must they prove? Either to get a nullity or a recount of the electoral votes. What's very important for court to determine before they allow for things like what happened in Masaka to happen, for decisions like that to be made? Thank you.
Thank you, Chemtai, for that question. Obviously, electoral justice is one of the areas where I'm heavily involved and passionate. So I will begin with the conclusion. Not to depress anyone, but I will begin with the statistics. 2021, the number of petitions that were filed in the whole country were between 110 and 120. Less than 8 petitions were allowed or succeeded in the entire country. 2016, petitions which were allowed were probably between, I think, between 15 and 20, if I recall, or between 12 and 20, around there. So, the starting point is that many petitions do not succeed. Every time I get an opportunity to address judicial officers about this area, there is one point I brought to their attention. I told them, you see, there is, for example, this thing called voter bribery. Everyone who does it, we all know that everyone who does it. But hardly any election petition succeeds on proving voter bribery. And I posed the question, I asked the lordships, so is this because voter bribery is a myth, it doesn't happen? Or is it because there are other considerations why there is reluctance to nullify elections? Now, election disputes by their very nature are now, this is real politics. Elections are about politics. And world over, you are not going to get any place where you get people who are happy with how the judiciary resolves election matters. Whether you go to the United States, you are always going to find that Republican appointed judges are going to rule in a certain way. Democrat appointed judges will rule in a certain way. When it comes to all those disputes, whether about gerrymandering, about boundaries, about voting, the Voting Rights Act, the scope and all, it's always going to happen. Why? There are many considerations. But you know, if I'm the one who appointed you and you're going to decide petitions involving my interest, it is a natural thing that you'll always want to look out for me. That's one. But two, there is also this idea that some judicial officers have. It's not entirely far-fetched. That you know, people should solve these things without bringing them to court. Elect your leaders and move on, get on with it. That is why in Tanzania, they have no presidential petitions. That you can't challenge the result of a presidential election. Although I know they are learning that probably it was never a good idea after several unnecessary deaths. Now, election matters. First of all, I must say, and I've left the conclusion, so now I can go to the beginning. Election matters are not just about being able to win. One, they are about the public record you want to build. Election matters are also about your supporters as a candidate. And three, election petitions are also about forcing the system to self-correct. Some errors will be corrected because they keep coming up in legal challenges. And if everybody is contented with the quality of elections, our elections won't get better. So even if petitions don't succeed, it doesn't mean they are useless. And that's what, for me, I will continue to file election petitions. No one will ever convince me that that one is a cadre judge, this person is opposition, don't give up. He didn't file a petition, but he stood. And 2026, he now wins his election. Gave up. He didn't file a petition, but he stood. And 2026, he now wins his election. What did that mean? When I'm your supporter, and I have voted for you and you are cheated, and you come back to Kampala and move on with your life, I will Kampala and move on with your life, I will never take you seriously again. You don't have to go to a therapist is not going to provide this kind of value. You have lost an election. Your supporters were beaten up. What can you do for them? Nothing. Your supporters are in prison. Some of them are saying, the declaration of results forms were changed. So and so has been declared. And then you go home and sit and you say, but you see, if we go to court, we shall lose, you see. No, go to court and lose. Let the ordinary citizens know that for you have done your part, but the courts have let you down. You have brought the evidence before the courts of law and they have let you down. And therefore, I think, number one, election petitions have immense value in cleaning up electoral democracy. And you cannot get good quality elections if irregularities and illegalities are permitted to go unchallenged. 2021, I had a very curious election petition from Chisoro. The Electoral Commission, while printing ballot papers for one constituency, put the wrong names of all candidates. And the party symbols were correct, the pictures were fine, but the names were of candidates from a totally different constituency in Bushenyi side. These were people in Chisoro, over 150 kilometers apart maybe. the run-up was not interested in challenging the election result. But one candidate, a young man who had 106 votes, 106 votes, came to me and said, for me, I want to petition. The returning officer had told him that, but you, young man, what? Others have 10,000 votes, you have 106 votes, and you are not complaining. Whom do you think you are? I told the young man, bring that petition, I'm going to file it. I'm going to file it. And I will pursue it up to the Court of Appeal. The High Court dismissed the petition. The Court of Appeal allowed it and ordered the by-election by a majority of 2-1. On the grounds that this error made the ballot paper void, so they never had a proper election. Yeah, my guy went back for the by-election and still got his, he improved his tally by like around 50 votes. But he vindicated himself. And so I was happy when I saw that in this electoral cycle, the Electoral Commission on its own repeated 2 elections when there were errors on the ballot paper. In other words, they learned that when you have errors on a ballot paper, cancel the election and do it properly. Now, if that young man had not gone to court in 2021, we would now be having so many elections where the ballot papers have errors. So he did his job. We should be proud of it. In the current dispensation, he probably doesn't stand a chance being an MP. Even now he contested and still got his usual margin, around 200 votes. But he has made a contribution. And guess what? When we allow mediocre standards to creep into our how we conduct elections, it is also why our public service is what it is. We complain about the quality of services, of public services, because citizens do not take any legal action. If UEDCL is going to wake up tomorrow and say we are shutting down power for 12 hours maintenance works in the middle of the week, and no citizen is asking, but is this legal? Shouldn't they be compensating us for this carelessness and inconvenience? When nobody rises up to ask public authorities to account, then it will be reflected in the quality of public services the citizens get. And so election petitions must be seen in that broader framework. So when we look at the decisions on recounts, obviously, I know everybody has been now thinking about recounts because of the Masaka City situation. And it's very unfortunate what unfolded in terms of the law. And we'll let the courts decide it whichever way they go. But again, it is also true that the Parliamentary Elections Act, actually had a gap on vote recounts. The law didn't expressly provide for what do you do when you find ballot boxes tampered with. Instead, High Court decisions kept saying once a ballot box is tampered with, no recount. But I remember in 2012, 2013, there was an issue in respect of a by-election for the woman MP for Luwelo. There was a petition between Honorable Brenda Nabukenya and Rebecca Naranga, where the margin between the winner and the run-up was around 36 votes. And then a recount didn't take place because seals of the ballot boxes were broken. But the returning officer insisted that the seals had been broken during transportation and the contents were intact. And the Court of Appeal, in fact, in that matter, had pointed out that if seals are broken, but the contents are not tampered with, or there is a reasonable likelihood that the contents are not tampered with, proceed and conduct the recount. But now it has become a pattern. The decision which was made in Winnipeg, that once a ballot box is tampered with, close the recount. Of course, it caused a mischief. Now every recount. I participated in a recount application in Kasese, where the margin between the candidates was 85 votes. We got the recount order, and guess what? The ballot boxes are tampered with. No recount has taken place successfully without a complaint about ballot boxes being tampered with. So maybe it's time for Parliament to cure this problem one way or the other. Either we go the Kenyan way and say that once the election is done, custody of electoral materials should go to the judiciary immediately. So when I apply for a recount, I don't need the returning officer to be involved anymore. But clearly, the current system that we have is unsatisfactory, and we need to revisit the law on recounts. But that having been said, applying for a recount, the legal principles are not difficult. Number one, what's the margin between the winner and the runner-up? Below 50 votes, the law requires an automatic recount without even going to court. But I was surprised to learn that many returning officers were telling candidates to first go and get a court order. But a recount, where the margin between the winner and the loser is less than 50 votes, the law requires the returning officer to automatically conduct a recount. As long as there is an application by way of a letter to the returning officer by an aggrieved candidate. I saw around 2 cases in this current general election cycle where returning officers refused outrightly because probably they didn't know the law, and that's unfortunate. Because I think one was a margin of 36 votes, another a margin of 22 votes. Those require an automatic recount once one of the parties, any of the candidates, applies for it. That's the law. Now, when it comes to petitions, what do parties need to prove? There are two things that confuse people. One, election offenses. If a candidate who won the election committed an election offense, that is enough to nullify the election. It doesn't matter if the candidate won overwhelmingly fair and square. What are election offenses? Voter bribery, giving illegal donations. Everyone who goes to churches during the campaign period and says, you are building. Even churches conveniently organize fundraisings during the electoral cycle and gives you bags of cement. That's actually an election offense. Even a promise of, we are now in campaigns, but after campaigns I'll bring you 2 million shillings. That's an election offense. There are so many election offenses that a candidate could commit. If a candidate commits an election offense personally and it is proved, you don't need to prove anything else. That alone is grounds on which a petition ought to succeed. That's one limb in terms of the law. The second limb is more complicated. When there are irregularities in the conduct of an election, for a petition results of 10 polling stations, yet the margin is 100. Of course, how can that election result stand? What you shouldn't do is go to court to simply say, at the other polling station, my supporters were beaten by the agents of so and so, or by police, or they were arrested. And the margin is 10,000, and you're complaining about some 5 or 6 polling stations. You'll hit a brick wall. You are not heading anywhere. If you are complaining about the quality of the election, it is not heading anywhere. If you are complaining about the quality of the election, it must be the quality of the election in the entire constituency, or in more than half of the constituency. Otherwise, if you are going into numbers, look at the winning margin and ask yourself, if this person won with a margin of 2,000 votes, how many polling stations had problems whose results should have been annulled? Are there 20 polling stations? Maybe you have a case. Are there only 3 and the winning margin is 10,000? You don't have a case. That's a major limb. Nomination of candidates. There are complaints about nominations. Sadly, the Court of Appeal, in my view, wrongly decided many matters regarding nominations in 2021 and has created a rule which makes it complicated. If you file a petition challenging a nomination, the Court of Appeal is going to say, did you raise this as a complaint to Electoral Commission or not? If you didn't raise it, then you are not allowed to raise it in an election petition. I don't think that's the correct interpretation of the law, but that's what the Court of Appeal decided in a number of election matters. And therefore, what you are proving in an election petition, in summary, either a winning candidate committed an election offense, or the agent of the candidate committed an offense with the consent, knowledge, and approval of the candidate. I can again tell you in very honest terms, proving that a candidate had consented and had knowledge of a doing by the agent is very hard work. I know of only one petition which succeeded on that point, where a candidate said, my person is coming next week to give you money, and the person indeed came. So there was an excess. But generally, election offenses by agents, it's not easy to impute them to the candidates. So that is also a limb which requires hard work. But election offenses committed by the candidate personally, you have the proof, bring it on, bring it up. You have videos, take them for forensic analysis. Remember, we are in an age of AI. So you need a video must be subjected to forensic analysis. Don't get a video of your phone and put it on a flash and bring it to court. I have seen so many such petitions being dismissed, and people go away saying, the judge was bribed. We even had a video of him giving money. The problem is the law, unfortunately, the rules of electronic evidence are very stringent. A video must go through a forensic analysis to be sure that it's not AI generated or it's not corrupted. So there are those areas in the election petitions and which affect electoral justice. But you prove an election offense by a candidate, personally, you have a case. No matter the winning margin, and no matter whether you got 10 votes as a candidate, it really doesn't matter. Or the winning margin is affected by the number of polling stations with irregular results or forged results or whatever, again, you'd have a case. Though generally, the threshold of election matters is around there. And that is why, partly, the number of petitions which succeed is very, very low. Obviously, like I earlier pointed out, partly, the number of petitions which succeed is very, very low. Obviously, like I earlier pointed out in my conclusion, a bit of politics is also expected and is involved. You can't wish it away, because this is a political disputes. The judges are not going to purely determine them on matters of law, unfortunately. The ideal is that they should stick to the law and the evidence. The reality is there will be those cases where you'll go home, you read the decision is from the Court of Appeal, I read and I simply laugh. Because I know that clearly the judges also know that what they decided was not correct.
Okay. Okay. Thank you very much. We are almost coming to the end. We'll go through another set of questions, but maybe I'll first read a few comments that have come through. I see Mr. Lule Alexander, who is the Law Society representative on Counsel for the Central Region, says that our practice is being taken. I think he's talking about bail. He says judicial officers no longer follow the law or have respect for the basic principles of the law, and our colleagues on the side of the DPP are making a disappointment of themselves. We are not in normal times, and we should not attack the situation normally. Anthony Nativ, I think, talks about studies. Are there studies on the cost? Are there studies on the cost of holding nearly 50% of prisoners of bail? Someone is asking about mandatory recounts. Brian is asking about mandatory recounts. And I think we have a number of other questions which I'll quickly go through them. We are really running out of time. We just have a few minutes left. I want to take you back, Jude, before we answer these questions. And very briefly, I want to take you back to questions where we started from about the Law Society. In December of last year, the Law Society endorsed candidates within national elections. I gave my view, my well-known, somewhat controversial view. For some, and really not controversial at all for others. In your view, is it appropriate for a professional society to be partisan, or must it remain institutionally neutral?
Interesting. Let's first look at this question then. Should a bar association be partisan? Should it be institutionally neutral? I think let's first define the terms because I think there's a bit of confusion. First of all, when we say the bar is being partisan, what do we mean? For me, when you say, for example, if tomorrow the Law Society issues a statement condemning the unjustified remand of National Unity Party platform supporters, I do not think that's being partisan. When you condemn how the state is treating a certain political party or its supporters, that's not being partisan, and that should be very clear. What's being partisan is when you say, like the president did, that for us we are endorsing Robert Chaguranyi, flag bearer of NUP. We are endorsing Dr. Ebuku. We are endorsing Lord Mayor Elias Lukwago. That's what I understand by being partisan. Obviously, there is no way any professional body, whether a bar association or whoever, can start endorsing candidates and remain a professional body. When you do that, you see how many countries approach it. You may have a right to do it, but when you do it, then you cannot continue to claim that you are. So we have endorsed. It's as simple as that. And this error has happened to many bar associations. Even the American Bar Association is a good example. The American Bar Association generally used to give endorsements to nominees for appointments to the federal judiciary, and they would say so and so is good, so and so is not. But then Republicans have decided to start ignoring any endorsements from the American Bar Association. Why? Because there was a clear pattern that they would clear Democrat appointees, and then they started claiming that Republican appointees were not qualified, even when some of them had the exact same qualifications that Democrat nominees had. So it became obvious that the American Bar Association was basically partisan and favoring Democrat appointees. So a bar association, unfortunately, ours is a bit different. The American Bar Association, first of all, is optional. You don't have to belong to it. Now, Uganda Law Society, one of the complications we have is we are all conscripted into it by law. For us to practice law in Uganda, you must be a member of Uganda Law Society. So you are not going to conscript me into an organization that endorses candidates I may not support. It's as simple as that. When you conscript me, but you are condemning matters which touch rule of law, even if I'm an NRM supporter, but people are being unfairly denied bail and they happen to be NUP supporters, you must speak out. That's your role. That's the whole point. Because even when you become a judge, you are going to hear cases involving NRM and NUP. That's the whole point. But if we become a pressure group or a political platform for some politicians, then there is no way we can claim we are furthering the public good for everyone. And that legitimacy is what allows us to get into certain spaces. For us to engage the judiciary, I believe NUP has every right, for example, to lodge complaints to the principal judge and complain about the mistreatment of its supporters who are being denied bail in very unfair circumstances. But when the principal judge looks at a complaint by NUP, is supposed to be different from how she looks at a complaint from Uganda Law Society. Because Uganda Law Society is looked at as we are supposed to be looking out for everyone, irrespective of their political affiliation. But you know, if the principal judge is going to form the view that Uganda Law Society is a pressure group for National Unity Platform, then the way she looks at our complaints, she is going to assume that there is politics in these complaints. We are not professionals. We are not giving professional positions. We are giving partisan positions. If Uganda Law Society were a voluntary body where you can opt out, and then they choose to endorse candidates because the members want it, there would be no problem with it. Because if I don't like it, I will opt out of it. They endorse candidates whom I don't support, I opt out. But right now, the law conscripts all of us into Uganda Law Society. And so when we endorse candidates, we are forcing a conversation which I think we need to avoid. We are forcing a difficult conversation about should Law Society be conscripting us if it has chosen to endorse candidates? Should the judiciary be helping Law Society to enforce payment of membership dues? Because the law requires that for me to get a practicing license, I must pay membership to Uganda Law Society. But when that law was enacted, it didn't envisage that maybe Uganda Law Society would one day endorse some candidates. If that were envisaged, it is probable that they would have said you can belong to Law Society or you cannot. If tomorrow the Chief Registrar said, okay, Law Society, we shall not, since you have decided you don't want to follow what is in the Uganda Law Society Act, even us as judiciary, we shall not follow what is in the Advocates Act about Law Society. Members, come and get your PCs. You don't have to prove payment of membership to Uganda Law Society. If they did that, you'd probably see that a significant number of members would refuse to pay membership to Uganda Law Society. Do we want that to happen?
No.
I don't know. Maybe our leadership will guide us. Because at the end of the day, there's going to be a difficult conversation on whether you can, in good conscience, say you are custodians of the rule of law and you want to endorse candidates and not positions. By the way, even endorsing positions has its tricky aspects. Because you see, a professional advisor doesn't take decisions for you. A professional advisor is simply competent. We are competent in matters of law. We should be able to tell the government that this is right, this is wrong. We should be able to issue statements like our vice president has been doing, our president has been doing, to condemn the arbitrary arrest of NUP supporters. We should do this without losing sleep that they will say, you are NUP supporters. We should be able to complain on behalf of anyone without being bothered. And that's why you'll find some of us in my practice. I have had occasions when some friends were saying I'm an opposition lawyer because of some of the notoriety which comes around some of the cases I've been involved with, like the presidential petition. And then last year, they saw me representing people before the NRM tribunal. And then some said, hey, what are you doing here? I said, yes, I'm representing my clients. And I was appearing before some of them who had been saying, I'm an opposition lawyer. Even in this every electoral cycle, I represent national resistance movement candidates and opposition candidates. Even in this very cycle, I will certainly have petitions where I'm representing NUP candidates petitioning. I'll also have petitions where I'm representing NRM candidates petitioning. Because for me, I look at it from that professional point of view. That's why I told you, for me, it's a day job. It's not an I'm not an activist. But no one is going to intimidate me that I'm going to be scared that because I will be labeled an opposition lawyer, I will fear to represent an NUP person. No way, it will not happen. But also, I'm not scared that NUP people are going to accuse me of being a system stooge or what. So I will not represent any of them people who are aggrieved. I will represent them, including against NUP candidates who won. I have been doing it and I'm very consistent about it. And so I think Uganda Law Society is losing a moral voice in endorsing candidates. I think it was a mistake, which we should avoid in the future. And but like I said, if members want it, they should have it. But for heaven's sake, we cannot conscript people. We cannot conscript people into a body that wants to take political positions of endorsing particular individual candidates. If we must do that, we must have the guts to say let membership in Law Society be optional. Don't conscript us. If it is optional and you endorse a candidate that I'm happy with, that year I will pay your membership. When you endorse a candidate I'm not happy about, that year I won't pay. And then the leadership will learn the difference. But right now we have a situation where the law conscripts us. We have taken a position that the aspects of the law we don't agree with. And indeed even me, the aspects of the law I think are constitutional. Demanding for receipts of ULS to people who are applying for practicing certificates. Let's be consistent. If we want to be let's be consistent. And then when we endorse candidates, nobody will come. If we endorse candidates, when members are conscripted by law into belonging to the body because the assumption is professional, then is not being partisan. That should be clear. Therefore, nobody should gaslight us into thinking that we are being neutral by complaining that we are being partisan. Being partisan is about endorsing individual candidates. But speaking out about mistreatment of whether individual candidates or political parties is not being partisan. That's a question of rule of law. And therefore, we have to be very clear whichever way we want to take it.
Thank you. I think we've taken, it's now 9:30. We've taken, I think, more time than we had promised. So we're going to our last question. I think it's now 9:30. We had promised to finish earlier. Judy, you have our apologies. Just there are a series of questions we had, but I'm going to break them all into one. At the recent opening of the new lawyer, the learned Attorney General said that 14 trillion shillings is held in backlog. I think if I heard him properly, of which almost 2 trillion is held in the commercial court. We have, as you had said yourself, people, by and large, across the country, a number of cases that are in the High Court. I think a recent judicial report found that the average remand time for pre-trial detention is 2 years. So every Ugandan who gets remanded awaiting trial, that if you are more likely to spend a minimum of 2 years before your trial is concluded in the court system. So my question to you is about backlog. Primary causes of case backlog in the judiciary and solutions. We have proposed here mission-based judges. What do you think about mission-based judges, but also what do you think are the primary causes of backlog? Remembering some of the challenges. It's an economic stranglehold on Uganda, trillions of shillings tied up in the judiciary. It is injustice beyond, it is land disputes, it is. So what do you think are the primary causes of this backlog, and what do you propose as a solution? For us, we've proposed mission-based judges. What's your take on it?
First of all, let me say that I have very strong reservations about this idea of claiming that 2 trillion is held up in the court. Some of those are fictitious claims. Others are claims where banks are suing people who are broke and will never pay. So this idea that money is held up requires a more scientific basis. But to simply look at the value of a dispute, and because the bank sued the ex to recover 4 billion from him, he has since he's financially ruined. He has no money. In the bank's records, they are like, the commercial court is delaying our case. There's 4 billion we are supposed to recover. We can't get it. But the defendant has no money. So the formula at which these figures of money purportedly held up in the courts involves a bit of fiction that I don't subscribe to. But that having been said, backlog is a problem that also arises from the institutional culture that starts from the bar and then gets to the bench, which is when you are a lawyer in a dispute, you want it resolved depending to the satisfaction of your client. But if I'm representing a borrower, like I do many times, who is broke and has been sued by the bank, of course I want to buy as much time as I want. That contributes to part of the backlog in the commercial division. Not just about borrowers, about people in default on contractual obligations. That will contribute to backlog. Then I meet a judge who is also worried. What I've learned over the years from observing the judiciary. I studied the judiciary very keenly with a very open mind. And I don't consider myself a critic of the judiciary. I consider myself a supporter and partner of the judiciary in many respects. What I observe is that no judge wants to make a report saying they have a backlog of unwritten judgments. So it is in the best interests of most judges at trial to also drag trials to avoid that day when trial has ended and you must write a judgment. And the rule which says you must have a judgment within 60 days kicks in. So you will find the Honorable Justice Stephen Mubiru had a backlog of several unwritten judgments. I think there were over 100.
Over 300.
How did he accumulate it? He was doing his job of finishing trials as quickly as possible. You'd find him in court by 8 a.m., many times leaving commercial court at 7:30 p.m. Of course, he ended up having too many judgments to write. So how do other judges avoid that? By dragging every trial. And they are rewarded for that. So a judge such as Honorable Justice Stephen Mubiru, who has rushed his trials and concluded them, instead gets stick for delaying to deliver judgments. Yet there is Judge X, whom I will not mention, who writes only 2 judgments in a year and completes only 3 trials. And then that judge gets promoted and promoted.
Because he has no pending judgment.
Because they have no pending judgment. So it means they are performing well. There is a time one judge told me bluntly in a land trial, Counsel, your case is left with only 2 witnesses. Now we can slow down. And he started giving me adjournments of 6 months. And she ended up retiring even before the case was ended. So she retired without backlog. Because judgment wasn't ready. And therefore, unless and until we have a tool which focuses on how many trials, first of all, are these judges concluding, we will never solve backlog. Because the system, what I understand is that the performance tools they are currently using are going to focus on how many judgments you haven't written. That is a horrible mistake that needs to be corrected to begin with. They must ask judges, how many trials have you completed before going to how many judgments? Otherwise, if you ask me how many judgments I have pending, I will always avoid having pending judgments by fixing as few trials as possible. It's very easy. Everyone can do it. And when it is that way, everyone can become a judge. But if you were asking them, how many trials have you concluded, then how many judgments? There are even people who would be scared of applying to join the bench because they would know it is a hard job. But right now, the job has been simplified. Avoid backlog. How do you avoid backlog? Don't complete trials. You'll even be promoted. And therefore, that's the system. So when we talk about mission-based judges, come in, get the job done, and leave. It's an attractive idea. But you see, the current ecosystem is designed to not measure performance based on how many trials have you completed. So the starting point, if you get that out of the way, you need to first ask the judges who exist, how many trials do they complete? If someone went and made research and picked, I don't know how, we have close, I think now, I don't know, I think we have over 100 high court judges now. On average, how many trials does a high court judge conclude in a year? The statistics would be ashaming. And that's where the problem lies. Mission-based judges, for me, I think could be a good idea, but not in this current environment. The current environment rewards an inability to get the job done. And so, for us to lift the veil of this backlog, we need to first ask ourselves, who is causing backlog? How is backlog arriving? That's the first problem. The second problem is that some of the backlog exists because some of the traditions which were in the judiciary have died out. There was a time you knew when you were going to appear before a panel in the Court of Appeal or Supreme Court, you must be very prepared. You are going to be asked plenty of questions because the judges have read your record and they know what your case is about. But what we see now is that appeals are fixed or constitutional petitions. You can clearly see they have fixed them. They have not read the files. They say, Counsel, have you filed everything? Yes. And then the head of the panel Any questions? Almost no one has a question. Okay, judgment on a notice. And that notice may mean 3 years. Then judgment is delivered and you realize they didn't actually have the certain things you submitted. They never even came across them. And so there is a way in which the system has internal checks that must happen. And they are not happening. We can have a lot of debate about the kind of cases that are filed that also contribute to backlog. Because obviously there are cases which shouldn't be in the system really. There are cases you see and you say, this one, what is this doing in the courts of law? It could be resolved out, or it's a dispute with a very simple point of law. I have complained in the Constitutional Court. I've asked the justices in the Court of Appeal how unfair it is for a constitutional petition to be filed. Then 4 years later, when it is fixed, someone is told, by the way, there was no question for interpretation in your petition. How difficult is it for the Constitutional Court to create a panel of 5 that sits monthly to sieve out these ones which clearly are unmeritorious petitions? And someone files it, you summon them immediately and tell them, yeah, no question for interpretation, this is dismissed. Must I wait for 5 years to be told that? You have no question for interpretation. And you see, so part of the backlog that exists is because, like I said earlier, the citizens have learned how the judiciary operates. So they will play the game. I have learned that if I file a court case, I can buy time. I will file it. I have learned that if a bank is pursuing me to pay a loan that I'm in default on, and I'm able to file and get an injunction, I can rest for 5 years. Of course, I will take the option. All citizens have learned that I steal someone's land and I'm in possession. So all I need is to make sure there is a running court case and I can be in possession for 15 years. In 15 years, I can actually build and collect rent that recovers the value of the land I put in. By the time the court pronounces itself, I have nothing to lose. And that's what is happening. That's why you'll find there is a backlog in land division, because people know the court cases are going to drag. So if I'm in possession of land that is not mine, why should I settle? I have zero incentive. So backlog is not just about judges being overwhelmed. It's about an institutional culture from on the side of judges, on the side of the bar, and the public. Because the public learns from what the bench does. If a lawyer tells a client that I can drag this thing, but you meet a judge who says, I won't allow you to drag it. Tomorrow you are coming for hearing. And tomorrow indeed the judge says, if you come without your lawyer, we shall hear it. You will still read your evidence. If your lawyer comes and you are not there, I will dismiss it. You will see how come Justice Muiru was able to finish many trials. That's what he was doing. So parties learned that, your case is before Justice Muiru. He's going to hear it. You won't play hide and seek with him. But also others know that when you are before justice so and so, he will adjourn for 6 months. Then you hear one witness, adjourn for 6 months. So if I line up 5 witnesses, I'm sure that I have covered 3 years. And so for me, backlog is also about a culture that first has to be rebooted. After you reboot it and you are sure that judges are giving value for money for the privileges they receive, is when you can say, okay, maybe can we think about mission-based judges to come in, get a few things done and go. That's my assessment of this issue.
Okay, ladies and gentlemen, if you are just joining us, we are happy to inform you that you're late. We are winding up a fantastic conversation, and I think everybody who is a lawyer, who is on this space, will agree with me that soon and very soon, the Judicial Service Conversations need to start being given accreditation for CLE points, because this evening we have received a comprehensive education. Not just a discussion, we have had a comprehensive education on bail and its history, on judicial service, on the causes of backlog, on the role of the Law Society, on what you need to look at in election petitions. And I can tell you, for me, it has been a fascinating conversation. Nothing less than what we expected. Honest, truthful, deep, powerful, consistent. Nothing less than what we expected. Jude being Jude, on fine form, firing on all cylinders. There are many people who have questions. Many people. But we cannot talk until the cows come home, unfortunately. And so I'm going to ask the final question. And the final question is a simple question. It's about your parting shots. And before you answer your parting shots, I think there have been many people who are here who want to know what you think about mentorship. So in your parting shots, if you tell us about mentorship. And then, usually we play a song at the end, and the song is usually Olimujawa, Musaja Singanze. But now it's embarrassing for me to play that song after listening to such a wonderful exposition from Jude himself. So we shall ask you, Jude, for a song. We shall give you the permission to wind us off with a song of your choosing. So over to you, Jude, and your final comments.
Okay, thank you. So my final comments, one, when we talk about the theme of these themes of the legal profession, courts of law, the future of practice, all of us have a collective role to play. First of all, to change the culture around legal practice. That role belongs to, of course, members of the public and the lawyers as well. Like I stated earlier, the quality of the judiciary we get today, the quality of the judiciary we get tomorrow, is a reflection of the quality of the legal profession, whichever way we think about it. And so that's why mentorship, of course, is very important. I have been fortunate enough to receive a bit of mentorship from various people over the years, both directly and some indirectly. What I usually tell, for example, young lawyers, what I used to do for me, when I read a judgment, and I'm probably impressed by the legal arguments made, which as reflected in the judgment, I would go and pay a court clerk to get me the record of the entire case, and I would read it from scratch. And that way I learned a lot of things. So, for example, I have never been directly mentored by the Attorney General Chigiwa Chwanuka, but I have read several cases he appeared as a lawyer, and I was always impressed by the quality of his pleadings, the depth of his research would impress me. It still does up to this day. And therefore, mentorship it requires a lot of creativity as well. There are people who you can learn from simply by looking for their work. There are others whom you can directly approach and ask to learn from them. We all do it. I still do it. I also ask many lawyers for ideas and all. So even the young ones should be doing it. Sometimes I tend to think that the younger generation tends to believe that they don't need guidance from the older generations, which is a bit different from us. Because for me, like after LDC, I would be willing to pay a fortune just to listen to certain people. But now I think there is this whole idea that the old people, what do they know? We know it all, which can be a very dangerous way to approach a mentorship and this whole idea of learning from people within the context, especially of the legal profession, which thrives on tradition. The word tradition, since I did some Latin, comes from the word tradere. The word tradere means to hand down. It's about handing down information. So it's something to learn. And of course, even the word education itself, educare, it means to bring up someone. That's the meaning of the word education. So when you talk about the legal education, about a legal tradition, it's about you joining a group and learning from the people you find, and then after you have learned from them, you can reject a few things, you can perfect others, then you can innovate. But you can't work upon you don't know much and you say you want to innovate. That's not how it works. And that's one of the criticisms I tend to see sometimes. And it is now very late at night. This is my first time, by the way. I told you that I'm a father of 6 kids. And I'm feeling terrible still being on this place at this time. Because they won't sleep until I'm home. Yes. Because I have to read for them a bedtime story. And so which song. I have very many tests. So let me give you a test that is unusual, that people will be surprised by.
Yes.
You get what is the love? Black Eyed Peas.
Okay, as we are getting that, where is the love? Colleagues, that is the question. Where is the love? And you can see the love is here. In the love week. And I think it's fair to say we haven't just had answers today, we have had clarity. I think it's fair to say that our guest Jude has been brilliant. Not in a loud sense, not in a theatrical sense, but in a disciplined, steady sense. A sense of someone who tells you that mentorship includes going to get the record and understanding what the lawyers have actually argued. He has reminded us that our law is not just a weapon we swing in moments of passion, but it is something of structure. He has, as this is a crucial time because the bar is debating itself and clashing with the bench. Our bail commitments to bail tests and to liberty are being tested beyond acceptable levels. Backlog is burdening the system, and it's easy to become impatient, to choose sides. But I think the rule of law is not noise, it's endurance. And our guest today has shown us the sheer patience of endurance, the art of a lawful trade, the art of a man who makes his living from his head, the art of advocacy, of understanding, of appreciating. So, I want to say that we have not just learned from you, Jude, how to resolve matters better. We have not just learned from you how to argue better, but the most important thing I think we have gotten is we have learned how to build better. And so we thank you as a great builder of our profession. And now, that building is where the love is. So, ladies and gentlemen, where is the love?
Oli mujawo musajja singa